I walked into court believing I was about to lose my savings over a mistake I didn't make. Not a criminal case, not some dramatic scandal. Just a neat corporate lawsuit with my name on the front and a number under it that made my stomach go cold. My own company demanded I make them whole for losses caused by my manager's favorite hire, and they were ready to pretend I'd volunteered to be the fall guy. I'm a guy who likes spreadsheets and quiet mornings. I don't raise my voice in meetings. I don't slam doors. I've never been written up. I always thought that counted for something. It didn't. The envelope came on a Thursday, taped to my front door like I was dodging rent. I stood there in my work boots, keys in hand, reading the first page 3 times because my brain kept refusing to accept it. Plaintiff, my employer. Defendant, me. Claim, negligence, breach of duty, financial damages. Amount sought, enough to wipe out my emergency fund, my car, and the little hope I'd built of buying a house before 40. At first I assumed it was a mistake, some auto-filled template, a clerical error. I called my manager, Martin, because even after everything, that reflex was still in me. Fix the problem, talk it out, keep it professional. He didn't pick up. I called again, straight to voicemail. I emailed, got served today. Please call me ASAP. I don't understand what's happening. No response. The next morning I showed up early and sat at my desk with my laptop open and my hands flat on the wood, trying to keep them from shaking. My inbox was quiet except for an automated calendar reminder and a company-wide email about integrity and accountability that suddenly felt like it was aimed at me personally. At 9:07, Martin finally sent one line. Please direct any questions to legal. Do not discuss with staff. That was when the fear turned into something sharper, because fear is what you feel when you don't know what's going on. This was clarity. He knew exactly what was going on. I worked in vendor operations for a mid-sized manufacturing company, big enough to have a legal department, small enough that everyone still pretended we were family. My job was boring on paper. Reconcile vendor invoices, validate contract terms, flag discrepancies, and route approvals through our workflow system. I wasn't an executive. I wasn't signing million-dollar deals on yachts. I was the guy who made sure the numbers matched the agreements before money left the building, and that was the hook they used. Our workflow had a step called finance validation. Whoever owned that step was the last person before payments got released. It didn't mean you created the terms. It didn't mean you approved the contract. It meant you verified the math and the documentation. And because I'd been competent and consistent, that step belonged to me. Martin was my manager. He was charming in meetings, the kind of guy who called everyone buddy and liked to talk about leadership podcasts. He didn't scream. He didn't threaten. He just had a way of making things your problem while smiling. 6 months earlier, he hired a woman named Kayla. She was younger than the rest of the team by a good decade, and from day one it was obvious she was his project. His talent. His proof that he could build a bench. Kayla was not stupid, but she was reckless. She acted like rules were suggestions meant for people who lacked confidence. She didn't ask questions, she announced decisions, and Martin rewarded that like it was courage. The first time she caused trouble, it was small. She bypassed our vendor onboarding checklist because it was too slow, and we had to scramble when compliance rejected the vendor at the last minute. Martin laughed it off in our team meeting. Love the initiative. We just need to align on process. The second time, it wasn't small. She entered pricing terms into the contract system from a vendor quote that was clearly marked draft. I caught it in validation and sent it back with a note. This is draft pricing. Please confirm final rate sheet and attach signed quote. Kayla replied, it's fine, same as final. I wrote back, it's not. Vendor changed rates last quarter. Please confirm. Martin stepped in, not to support me, to unstick the workflow. He messaged me privately. Let's not slow roll this. Kayla says it's fine. Push it through and we'll clean it up if needed. I stared at that message for a long time. because it was the first time I realized how little protection doing things right actually gave you. I still didn't push it through. I escalated politely, like I always did. I asked for confirmation in writing from the vendor. I documented the discrepancy. I did everything by the book because I thought the book mattered. Martin called me into his office that afternoon, door half open like he wanted the hallway to hear how reasonable he was being. "You're a great worker," he said. "That's why I trust you. But you've got to loosen up. We can't operate like a government agency." "I'm not trying to slow anything down," I told him. "I just need the final terms. If we pay on draft pricing—" He cut me off with a laugh that wasn't warm. "You're catastrophizing. Kayla has a relationship with them. It's fine." That phrase, "Kayla has a relationship with them," became the excuse for everything. It was also the beginning of the end, because the big loss didn't happen all at once. It happened the way corporate disasters usually happen, in small approvals, in rushed emails, in just this once, in the silent pressure to be the person who doesn't make waves. Then one Friday, accounts payable released a batch of payments tied to Kayla's vendor portfolio, and on Monday the vendor disputed the rates. Not a little. Not an adjustment. A full documented "you underpaid us" claim that traced back to the exact draft terms I'd flagged. I expected a messy meeting. I expected a slap on the wrist. I expected Kayla to get coached and Martin to get embarrassed. What I didn't expect was to be served at my house with a lawsuit that treated me like the architect of the entire failure. By Monday afternoon, Lee Gale had put a litigation hold on my email and told me not to access certain folders. HR sent me a polite invitation to a meeting that wasn't labeled disciplinary, but felt like a trap. My access to the contract system suddenly required approvals that didn't exist a week earlier. And Martin walked past my desk without looking at me like I was already a former employee. That night, I sat at my kitchen table with the complaint spread out like a crime scene photo. The language was cold and surgical. It didn't say mistake. It said dereliction. It didn't say process failure. It said personal responsibility. I kept rereading one line. Defendant approved and released payments contrary to vendor terms. I hadn't. I knew I hadn't. And the fact they were willing to write it down and file it in court meant they believed they could make it stick. I opened my laptop and did the first thing I should have done months ago. I stopped trusting the people around me to tell the truth, and I started pulling receipts. I spent the weekend doing something I'd avoided my entire career, treating my own company like an adversary. Not in a dramatic way. No rage emails, no threats, just quiet, methodical preparation, like you'd pack for a storm you can already see on the horizon. On Monday morning, HR finally called me in. 2 people were there I'd never met before. Legal, not HR. That alone told me everything. HR doesn't bring lawyers unless the story's already been written. They were calm, almost kind. They explained that the company had suffered material losses, and that after an internal review, my role in the approval chain raised serious concerns. They stressed that this was procedural, not personal. That phrase came up a lot. I asked a simple question. Who entered the pricing terms? They exchanged a look. "That's not relevant," one of them said. "What matters is who released the payment." There it was, the shape of the trap. I kept my voice steady. "My role is validation, not authorship. All entries originate upstream." The lawyer smiled politely. "According to our records, you approved them." I nodded. Approved the math against the documents provided. Another look. Longer this time. After the meeting, my system access was quietly restricted. Not revoked, restricted. Enough to do my job, but not enough to see the bigger picture. It was subtle, professional, and intentional. That night, I logged in from home and started pulling everything I still could. Our workflow system logged more than people realized. Version history, comment threads, timestamps down to the minute. I exported everything tied to Kayla's vendors, every rejection, every note, every escalation I'd made. I saved PDFs, I renamed files clearly. I backed them up twice. Then I went into my email. I searched my own sent folder with terms I hadn't wanted to think about. Draft, confirm, cannot approve, risk. Dozens of results. There were emails where I'd flagged discrepancies. Emails where I'd asked Martin to confirm overrides. Emails where I'd spelled out, in plain language, what could go wrong if draft pricing was used. And there it was, the message I'd almost forgotten. Let's not slow roll this. Push it through and we'll clean it up if needed. I stared at it for a long time, because that one sentence changed the entire story. The next day I got a formal letter from legal instructing me not to discuss the case internally and reminding me of my duty of cooperation. It read like a warning dressed up as policy. Martin still hadn't spoken to me directly. Kayla had stopped making eye contact. People on my team avoided my desk, like proximity itself might be dangerous. And that's when I realized something else. This wasn't just about money. It was about protecting a narrative. If I went down quietly, the story stayed simple. One negligent employee, one unfortunate loss. No management failure, no favoritism, no oversight issues. But the records didn't tell that story. I hired my own attorney that week, a quiet guy with a background in employment defense and zero interest in theatrics. I slid the files across his desk and said, "They're saying I approved losses I warned them about." He didn't react right away. He just read. Then he leaned back. "They picked the wrong defendant?" Discovery moved faster than I expected. Corporate cases always do when one side wants to scare the other into settling. I was offered an off-ramp, a reduced repayment, no admission of guilt, quiet resignation, clean on paper. I said no, because once you accept their version, it becomes the only one that matters. When my attorney requested the full audit logs and internal communications tied to the contracts, the tone shifted. Deadlines slipped. Responses got narrower. They claimed certain records were not reasonably accessible. We pushed. Then came the deposition notices. Martin was listed, so was Kayla. And suddenly, people wanted to talk. A former colleague forwarded me a calendar invite from months earlier. An approval meeting I'd been excluded from. Another sent a screenshot of a Slack message where Martin told Kayla, "I'll cover it if finance gets weird." By the time the court date was set, the company had stopped calling me negligent. They started calling me mistaken. That's a small word, but it matters. The night before the hearing, I sat in my car outside my apartment and didn't go inside right away. I thought about how close I'd been to believing them, to apologizing for something I didn't do, to paying for silence. I didn't know it yet, but by the time I spoke in that courtroom, the story they'd built around me was already collapsing. They just hadn't heard the sound yet. The courtroom wasn't dramatic. No wood-paneled theater, no gas, no raised voices. Just beige walls, fluorescent lights, and a judge who looked like he'd rather be anywhere else. That made it worse, because this was the kind of room where quiet lies survive. Martin sat 2 rows ahead of me with the company's attorneys, posture relaxed, hands folded. He nodded along as if this were just another meeting he'd prepared for. Kayla sat farther down, staring straight ahead, jaw tight. She hadn't looked at me once. When my name was called, I stood, walked to the table, and felt the weight of months of pressure settle into something oddly calm. Not confidence, focus. The company went first. Their lawyer laid out the story cleanly, too clean. A responsible organization, a trusted employee, a breakdown in procedure, losses that had to be recovered. My name appeared on the approval chain, highlighted on a screen like a fingerprint at a crime scene. They didn't call me reckless. They didn't call me malicious. They called me careless. Then my attorney stood up and asked for permission to begin with exhibits. The judge nodded. We didn't argue feelings. We didn't argue intent. We argued records. First came the workflow logs. Every rejection I'd issued. Every note I'd left. The timestamps showing delays that weren't indecision, but resistance. The judge leaned forward slightly, not impressed, just attentive. Then the emails. I watched Martin's shoulders stiffen when the screen filled with my message history. Short, factual warnings. No drama. Just consequences laid out in advance. When the line appeared, push it through and we'll clean it up if needed. The room changed. Not loudly. Subtly. The company's lawyer objected, tried to reframe it as informal guidance. The judge let it stand. Then Martin was called. Under oath, he did what he always did. He smiled. He explained. He positioned himself as supportive but distant. He said he trusted his team. He said he didn't recall specific messages. He said he never instructed anyone to bypass controls. My attorney asked him if he recognized the email. He hesitated. Long enough. Yes, he said finally. That appears to be mine. And when you wrote, clean it up, what did you mean? Martin cleared his throat. I meant we'd reconcile any discrepancies later. So you were aware there could be discrepancies? I wouldn't say aware, but you anticipated the risk. Silence. Then Kayla. She looked smaller on the stand, less certain. When asked who entered the pricing, she admitted it was her. When asked what document she used, she said the draft. When asked why, she glanced at Martin before answering. He said it was fine. The company's lawyer tried to redirect, tried to emphasize my approval, tried to pull the focus back to me. That's when my attorney asked for the audit trail, showing who changed the contract fields. Kayla's login ID appeared on the screen, followed by another entry. Martin's. He hadn't just encouraged the override. He'd edited the record after the fact. Not enough to erase it, just enough to blur it. The judge didn't raise his voice. He didn't need to. He asked one question. Why was a manager modifying contract terms without documenting authorization? No one answered immediately. In that pause, I felt something break. Not in me, but in the room. The company's story no longer held its shape. When I finally spoke, it wasn't defensive. It wasn't emotional. I explained my role. I explained the process. I explained why I documented everything. I explained why I refused to approve without confirmation. And I explained what it felt like to be sued for doing exactly what I was hired to do. No speeches, no anger, just facts. When it was over, the judge recessed for less than 20 minutes. When he returned, he dismissed the claim against me. Not delayed, not reduced, dismissed. He ordered the company to cover my legal costs and referred the internal conduct issues back to their board. Martin didn't look at me when it happened. Kayla cried quietly. And for the first time since that envelope hit my door, the air felt breathable again. The case didn't end with a bang. It ended the way RAL accountability usually does, quietly behind closed doors, with paperwork no one celebrates. 2 days after the dismissal, my attorney forwarded me an email from the company's legal department. The tone was different now, careful, neutral, almost respectful. They confirmed the judge's order, asked for invoices, and said someone from HR would be in touch regarding next steps. And Martin was placed on administrative leave that same afternoon. No announcement, no goodbye email. His calendar just disappeared from the system, like he'd never been there. A week later, his LinkedIn headline changed to Open to Work. Kayla was gone too. Officially a mutual separation. Unofficially, everyone knew what it meant. Favor doesn't protect you when the receipts are louder than the excuses. HR finally scheduled a meeting with me. This time, no lawyers on camera. Just a director I'd never met and someone from compliance who kept nodding, like he was trying to convince himself this was over. They told me the company had reflected deeply. They said the lawsuit was a misjudgment. They emphasized how seriously they took retaliation and improper management conduct. They offered a settlement to cover damages, fees, and a little extra, framed as goodwill. I listened. I asked questions. I didn't argue. Then I declined reinstatement. That surprised them more than anything else I'd done. They assumed winning meant I'd want my job back, my desk, my badge, my quiet corner of the building where none of this had started. But something had shifted while they were busy protecting themselves. I didn't want to work for people who'd looked at a clean paper trail and decided the easiest solution was to ruin the person who kept it. So we finalized the settlement. Neutral reference. No admission of fault on either side. Clean exit. On my last day, I packed my things in the early morning before most people arrived. A few coworkers stopped by, awkward but sincere. One said, "I'm glad you fought." Another just nodded like he finally understood something he hadn't had words for before. No one from leadership came down. I walked out with a box under my arm and felt lighter than I had in years. A month later, I started a new role at a smaller firm. Less flashy, fewer buzzwords, better controls. During onboarding, my new manager told me something that stuck. "We don't punish people for documenting risk," he said. "That's the job." I didn't tell him why that mattered so much. Sometimes, late at night, I think about how close I came to settling early, to signing something that would have labeled me careless forever, to paying for peace instead of earning it. The system didn't save me. I did, by staying boring, by writing things down, by refusing to move faster just to make someone else comfortable. Martin thought loyalty ran downward. The company thought pressure would make me fold. They were wrong. What saved me wasn't a clever speech or a dramatic reveal. It was a trail of small, unglamorous decisions, made when no one was watching. And when the moment came to speak, I didn't raise my voice. I just told the truth, one record at a time. That was enough.